I'm Richard Meeran. I'm the head of the International Department at Leigh. Welcome to this discussion on the Hague Rules on Business and Human Rights Arbitration. Improving access to remedy is the subject of Pillar 3 of the United Nations Guiding Principles. But although law has developed significantly in certain jurisdictions, access to remedy remains elusive to many victims of corporate human rights abuse. Arbitration, a widely used extrajudicial means for resolving commercial disputes, has rarely been considered, let alone utilised, in business and human rights cases. The Hague Rules, launched in December 2019, represent a novel approach to the resolution of business and human rights disputes and significantly modifies the UNCITRAL arbitration rules to cater for such disputes. The rules are not intended as a substitute for judicial remedies, but as an alternative mechanism that in certain circumstances serves the interests of both businesses and victims and fills the judicial remedy gaps in the UN Guiding Principles. Resolution of disputes under the rules could be stipulated in investor agreements and contracts within supply chains. Thus, the Hague Rules are also intended to cater for business-to-business disputes, in particular to enable the enforcement of contractual human rights commitments pursuant to Pillar 2 of the UNGPs, the corporate responsibility to respect human rights. But the focus of our discussion today is on disputes between human rights victims and business. In the context of a human rights dispute, the objectives of business on the one hand and victims on the other seem diametrically opposed. Given, as we will hear, that consent is a prerequisite to arbitration, how likely is it that an agreement to arbitrate will be reached? Surely, if victims have access to judicial remedy, they will have no interest in arbitration. But if a judicial remedy is impossible, why, from a purely financial perspective, would a business open itself up to arbitration? And if it did, wouldn't it try to ensure that the rules to which it agreed gave it the upper hand, thereby reducing the value of the rules from the victim's perspective? So we want to consider today the extent to which and in what circumstances arbitration under the Hague Rules might be in the interests of both human rights victims and business. I'm delighted to be joined today by three very knowledgeable and experienced experts who come at this subject from different perspectives. Professor Stephen Ratner is the Bruno Simmer Collegiate Professor of Law at Michigan Law, University of Michigan. Since 2009, he's been a member of the State Department's Advisory Committee on International Law, and he is also a counselor of the American Society of International Law and a member of the American Law Institute. Stephen is a member of the Hague Rules on Business and Human Rights Working Group. Egbert Wesselink serves as a senior advisor at PAX, the Dutch peace movement. He's a historian by training, and before joining PAX, he worked in a number of roles, including as human rights officer with UNTAG and as a Russia-Caucasus expert with the UNHCR. He represented PAX in multi-stakeholder initiatives, including the Dutch Coal Dialogue and Better Coal, and is currently serving on the steering committee of the Voluntary Principles on Security and Human Rights. His report, Unpaid Debt, sparked a war crimes investigation in Sweden, which is ongoing. Anna Kirkpatrick is a senior associate at Clifford Chance, LLP, specializing in international arbitration, international law, and business and human rights. She advises on business and human rights issues, including due diligence, risk management, and dispute resolution, and has recently assisted multinationals with specific instances where it is alleged that the OECD guidelines on multinational enterprises have not been met. She sits on the IBA's Business and Human Rights Committee and is a trustee of Lawyers Against Poverty. I should also declare my interest as a member of the Hague Rules Working Group. Before I go on, I should just mention as well that on the Q&A function of the webinar, you should find links to the Hague Rules, and also a useful Q&A on the rules, which there's also a link to that. So we're going to start with an overview of arbitration and the Hague Rules, and then have a more detailed discussion with our speakers on various aspects of the rules from their different perspectives. And hopefully that will leave quite a bit of time at the end for questions, which you can post on the Q&A section in the usual way. So, Anna, if I could just start with you, perhaps you could give us a very brief general outline of what arbitration is and why businesses prefer it, as well as just an explanation of how enforcement of arbitration awards works under the New York Convention.
Sure. So arbitration can take many forms. For today's purposes, we're going to be referring to international commercial arbitration because that's the type of arbitration on which the Hague Rules are based. At its core, international commercial arbitration is a consensual form of dispute resolution, and it caters for cross-border disputes, often of a commercial nature and usually in a confidential setting. Parties agree that disputes will be determined by independent and impartial decision makers selected through a process of the parties' choosing and according to procedural rules of the parties' choosing. The idea of arbitration was initially intended to avoid some of the barriers presented by court litigation that were hindering the efficient disposal of business disputes. And by agreeing to arbitrations, parties elect for the final resolution of their disputes through a system that, to a large degree, bypasses the court. That said, to support international commercial arbitration and that opt-out of the court system, states have created a legislative framework that allows parties to agree to arbitrate disputes under the supervision of national courts. And this supervision differs from country to country, but generally the court's role is to oversee the process and to ensure procedural fairness. States put in place checks and balances so that where necessary, the court can step in. States have also created a system for the recognition and enforcement of arbitral awards, which allows awards to be converted into court judgments and enforced against award debtors at the end of the process. Again, the safeguards in this part of the process differ from country to country, but generally, as long as there is procedural fairness evident throughout the process and in the award itself, then the national court will be happy to enforce it. The concept of arbitration has had huge support from international bodies, notably UNCITRAL. UNCITRAL pushed forward the New York Convention in 1958, under which state parties agreed to recognize and enforce arbitral awards from foreign countries. And again, this is subject to very limited oversight. And essentially, in summary, if the decision has been rendered fairly by independent decision makers and does not contravene public policy, then it can be enforced. And that treaty has had huge take-up and currently has 168 state parties. UNCITRAL also forged the UNCITRAL Rules, which is a basic framework of rules for ad hoc and non-institutional arbitration, and it is the set of rules on which the Hague Rules are based. A huge proportion of businesses prefer arbitration to litigation for a range of disputes. The key features that make it attractive are neutrality, enforceability, as I've just mentioned, flexibility, party autonomy, the ability to choose the neutral, choose and agree the neutral adjudicator, privacy and confidentiality, the limited opportunity for appeal, i.e. the finality of the decision, and the lack of precedent that would then bind parties in future decisions on similar issues. In other words, these are many of the features that the courts do not offer. So we're now seeing arbitration increasingly used in a wide range of contracts where the benefits of arbitration outstrip the benefits of litigation. And we've even seen bespoke rules for certain sectors, such as the finance sector. And in fact, whilst arbitration is typically used in a commercial context, states are also using it in other contexts, most notably in investment treaties. So these treaties, which are agreed are agreed between states and provide reciprocal substantive protections for their investors. And the treaty extends an offer to arbitrate to investors who can then sue states directly for any breach of their substantive rights. International commercial arbitration is offered in this context, often under the UNCITRAL rules or through arbitration institutions such as LCAA, Stockholm Chamber of Commerce, or ICSID. By contrast to most commercial disputes, there are public elements to ISDS, as it's referred to. For example, the treaty itself is an instrument of public international law, and states are challenged by investors on policy decisions that can affect citizens, decisions about health and environmental policy, for example. And when states lose, they sometimes, to the tune of billions of dollars, it's the public purse that is hit. Arbitration is by nature dynamic, and the rules of the game are frequently updated in line with users' needs. And in that vein, we've seen recent reforms of both private commercial arbitration, which focus on the efficiency of the process, bringing in mechanisms from court procedures, for example, to cater for multi-party disputes. And we've also seen a drive for transparency in investor-state arbitration, as well as in commercial arbitration. And that's coming about because in ISDS, we've seen a crisis of the legitimacy of the arbitral process, whereby ISDS is perceived by the public to be determining matters of public interest behind closed doors. Essentially, that's led to a lot of developments which are relevant to the Hague Rules because they've also been imported into the Hague Rules. Arbitration itself isn't referred to in the UNGP expressly, or not referred to in the third pillar in any event. The OHCHR has described arbitration as a state-based non-judicial grievance mechanism, which tallies with the court support that has been given to international commercial arbitration. That said, given the fact that courts are generally staying out of the process, it is also quite legitimate to perhaps categorize it as a non-state-based non-judicial grievance mechanism. For both state-based and non-state-based judicial grievance mechanisms, the UNGP refer to the need for those grievance mechanisms to be effective under UNGP 31. And it's against this context that the Hague Rules have the potential both to render arbitration more human rights compatible and also to potentially create a more appropriate grievance mechanism for business and human rights disputes.
Well, thanks very much for that, Anna. That's a useful introduction to arbitration. Stephen, perhaps we can start with a brief background on the process that led to the Hague Rules.
Sure. Thank you, Richard, and thanks to all of you for showing up at this webinar today. The idea of business and human rights arbitration originated in the wake of the Kiel decision in the US Supreme Court, after which a small group of predominantly European international lawyers led by Klaus Kronstedt of Sweden, who had worked on business and human rights issues in various capacities, began to explore the possibility of arbitration as a vehicle for the resolution of BHR disputes, as a way to provide a remedy under Pillar 3, but also as a way to help business carry out its responsibilities under Pillar 2 and manage a risk. The original working group discussed this idea with multiple stakeholders in business, civil society, arbitration institutions over the course of several years, and eventually created a larger working group and then expanding it to a 13-person drafting team consisting of specialists in business, in human rights, and arbitration. It was a combination of academics and practitioners hailing from 9 different countries, consisting of 6 women and 7 men, and eventually to a project that was supported by the City of The Hague, funded by the City of The Hague, and administered by the Hague-based Center for International Legal Cooperation. The drafting team's chair was Bruno Simma, former judge of the ICJ, current judge of the UN US Claims Tribunal, also former member of the Committee on Economic, Social, and Cultural Rights and the ILC, with experience in both the worlds of human rights and arbitration. So following detailed preparatory work, we began meeting in early 2018, and immediately thereafter created a sounding board of over 220 people from the business world, companies, business groups, law firms, as well as civil society, human rights NGOs, academic institutions, arbitral institutions, and representatives of governments, judges, and officials in international organizations. We produced an elements paper in the fall of 2018, and then a first draft of the rules in June of 2019. And these were all circulated to the sounding board and put on the website as they were produced. Our starting point was always to start with the UNCITRAL rules, but then alter them as needed to deal with the unique features of business and human rights, guided always by the principles in Principle 31 of the UNGPs for a effective non-state-based mechanism. We had to appeal, and we're constantly thinking about appealing to the key stakeholders in this process and not going too far in either direction, always trying to anticipate the reactions of civil society side and the business side, and have respect for the autonomy of the parties, but also have some very clear default rules that would govern. After the papers were shared on the website and we received responses from members of the sounding board, an enormous amount of feedback, in fact, we continued to work in 2019 and produced the rules by the end of 2019. They were formally launched in a ceremony at the Peace Palace in December of 2019 with representatives of the Dutch government, the city of The Hague, and the PCA in attendance. So the process lasted, I would say, roughly 5 years, the drafting itself about 2 years. And the result is this document that I have here. There are hard copies that we can send you. There, of course, is the version itself is available on the link that I hope has been shared with you on the Silk website. Thanks.
Thanks, Stephen. But before we move on to the detailed discussion of the rules, I'd just like to ask you some questions about some of the broad principles, if I can. And first of all, you've partly touched on this already. Perhaps you could just briefly explain what the objectives of the Hague Rules are, including the relationship between the rules and the UNGPs.
Sure. Well, the UNGPs were always the starting point for this idea because they anticipate a number of different possible remedies for victims of BHR-related abuses. And so in a sense, the Hague Rules are meant to offer a procedural framework and a new method for addressing those disputes. And they really have two goals, as I sort of quickly alluded to a minute ago. To create a new, the possibility of a new kind of remedy, a non-state-based, non-judicial remedy, as is contemplated in Pillar 3. And secondly, to offer a strategy for business to fulfill its responsibilities under Pillar 2. So there's really a dual function. It's about reparation and remedy on the one hand, but also about managing risk. It's a chance to provide a remedy, but also a chance for business to demonstrate if it chooses to, that it's serious about its responsibilities and prepared to accept accountability if it doesn't live up to its responsibilities or if its business partners don't. It's meant to apply across industries and sectors, and so we did not draft it with any particular kind of dispute in mind. It can go work for the extractive industries, the garment industries, sports industry, mega sporting events, food, IT, and is meant to be sort of multi-sectoral coverage.
And what human rights are intended to be covered by these rules?
I would say the full range of human rights, the same human rights that are covered in the UNGPs itself. We do not offer a definition of human rights per se, but we do make reference to the early principles of the UNGPs, which refers to the full gamut. And one can imagine all sorts of, some of the more obvious ones obviously would include labor rights, but there are so many others where we could imagine situations where a business is involved in abuse, just as the drafters of the UNGPs themselves could.
Now, these rules are certainly not intended to be a replacement for judicial remedy. They're there to plug a gap in the remedy. But so what is the relationship between the rules and the need to expand and develop judicial remedy access?
Sure. Well, when from the very beginning of this process, those of us involved in it always recognized the primacy, as does the UNGPs, the primacy of national courts to provide a judicial remedy. And they are, of course, the place where victims would typically turn to when the courts are functioning. And there's nothing in the Hague Rules that would discourage that at all. But frankly, as you hinted in your introductory remarks, there are some situations where there are advantages to both sides from arbitration. From the victim perspective, there are many, many situations around the world where courts are not accessible, where they're not independent, where they're plagued by corruption or capacity limitations. There are, of course, legal limitations in terms of doctrines of corporate law about the corporate veil, or jurisdictional rules that insulate business from responsibility. There are costs and delays. In other words, not every case is going to end up like Vedanta or a handful of other cases where Canadian or UK courts have recognized responsibility of their companies for their overseas operations. In most cases, courts are going to be closed. That's not to say that we shouldn't encourage them to improve their capacity and change their rules, but that's not so helpful for the victim of the abuse who needs a remedy now. From the business side, they may not wish to see the issue drag on through domestic litigation, but work out a solution in a way that's less confrontational. So in short, it's not meant to compete with national courts or the many efforts by stakeholders, intergovernmental organizations and non-governmental organizations to improve the capacity of courts to address human rights violations.
But just to be clear then, you couldn't envisage any circumstances in which a victim would be compelled to sacrifice access to judicial remedy for arbitration?
Compelled? No, I mean, arbitration is a consent-based process, and we'll talk a little bit more about issues about power imbalances during the process of attaining consent, but the decision by both parties has to be consensual.
Now, there are two main categories of business and human rights arbitration that is envisaged. We've got the business-to-business arbitrations and the human rights victims and business arbitrations. How is this different? There was a reference to investor-state arbitrations by Anna in her introduction. How are these processes different from the investor-state arbitration processes, which certainly from victims organizations, human rights organizations, have not had a good track record?
Sure. Well, let me just say one thing about the victim to business prong of the process, which is the one that we're focusing on in our discussion today. I would just point out that the term victim, which of course is a loaded term, many people prefer the term survivors, and so I use the term with caution. It includes a range of those affected by business activities. So it ranges from workers and unions and workers in all sorts of industries to members of a community who are negatively affected, whose human rights are negatively affected by a business operation, and even potentially a state could institute arbitration against a business should it choose to do so. Now, on the question of investor-state arbitration, either prong of these, whether it's business to business or victim to business, is completely different from investor-state arbitration. And I would say the vast majority of the members of the working group and the drafting team share and have written indeed in our own work about many of the problems of investor-state arbitration. First of all, the goal is not to provide a forum for a foreign investor to insert its rights against the host state. Rather, it's to provide a forum for different entities to make claims regarding violations of human rights by business. As we wrote the Hague Rules, we learned from and we were constantly informed by the debates about investor-state arbitration and its legitimacy problems. So that informed our drafting of the rules about transparency, about amici, about witness protection, about arbitrator qualifications. Indeed, the rules include the very stakeholders that have been excluded from ISA. They are front and center in business and human rights arbitration. And there are many procedural differences between these rules and, let's say, the ICSID rules. Finally, I guess I would just add is that unlike investor-state arbitration or perhaps international investment law generally, the regulatory role of the state under Pillar 1 to the primary role of the state to protect human rights of its citizens against abuses by private actors is not threatened by business and human rights arbitration. Rather, it's meant to be enhanced and complemented by giving victims an additional remedy where the state itself is not providing adequate protection. Investor-state arbitration, arguably, you know, at least in the view of those of us who are concerned about it, has the potential at least to limit the regulatory role of the state to protect human rights. And I don't think that should be a concern when it comes to business and human rights arbitration.
Thanks. Now, there are two routes to arbitration under the rules. One is if the Hague Rules are stipulated in a prior agreement, and the other is where an agreement is reached after something has happened, alleged human rights abuse has occurred. Perhaps you can just, I mean, that's correct, isn't it? I mean, how does that work exactly?
Sure. Well, the Hague Rules, like other arbitration rules, allow for the parties to express their consent to arbitration either before an alleged abuse takes place or afterwards. So the examples of where the consent to arbitrate or agreement to arbitrate would appear before in the so-called ex-ante situation would be in a supply chain contract or a labor contract or an investment authorization by a community or by a state, or in a multi-stakeholder agreement such as the Bangladesh Accord. A ex-ante consent would be in an agreement to arbitrate a specific dispute that's arisen. But either way, the parties have the flexibility under the key notion of autonomy that Anna discussed earlier, to spell out in that agreement to arbitrate exactly how they want the arbitration to work. They can specify the Hague Rules or as the procedure, or the Hague Rules with modifications. They specify the law that they will apply. They're free to opt out of them as they choose to, but of course we think that the Hague Rules offer a strong template for inclusion in agreements to arbitrate. And
just in terms of the process, perhaps you can give a brief explanation of that, Stephen. We've got, you've mentioned the key principle of consent. In addition, there's the ability to modify the rules, although I believe that is not encouraged too much. We've got the question of selection of arbitrators, and then the place of the arbitration, the role of the Permanent Court of Arbitration. Perhaps you could just briefly elucidate on those aspects.
Sure. So there is, it's a long and complicated process, but if I can just sort of highlight some of the key stages. So as I mentioned, the parties will consent either ex ante or ex post in the arbitration agreement, specifying the rules or some alternative. And they would, typically, although not always, specify the law to be applied, the place of arbitration. And if we have time to discuss the law, the place of arbitration becomes relevant at the enforcement stage. A case would begin by a notice of arbitration by the claimant, a response to that notice by the respondent, and then the PCA, which is sort of designated as this default institution behind these rules, would publish basic information about the case so people would then know about it. At this point, the parties, and again, I'm glossing over what are somewhat complicated rules. I would encourage you to look at the details if you really want to follow that. The parties would agree on the details about the appointment of 3 or possibly 1 arbitrator. The rules set out requirements for those arbitrators, most notably that they be of high moral character, but special requirements on the chair or the sole arbitrator that she or he have demonstrated experience in international dispute resolution in areas relevant to the dispute, which could include business and human rights. The tribunal is suggested that it be diverse. There's a strict and new code of conduct with the highest international standards regarding disclosure, conflicts of interest, double hatting for the arbitrators. The tribunal, if the seat is not already decided, the tribunal will decide on the seat, set a schedule for filing the claims and the defenses, and then begin to make decisions about evidence and about witnesses. The Secretary General of the PCA is the sort of default appointing authority. If the parties don't specify another appointing authority, conceivably the PCA could end up appointing arbitrators depending on how the parties are able to agree on those issues. After the tribunal produces an award, which normally would be public, it's then available for enforcement in the place of arbitration or internationally under the New York Convention.
Thanks. Well, I think that really sets the scene and should give everyone a reasonable idea of what this process entails and what it is designed to achieve. So if I may now, then what I'd like to do is to discuss some of the detail with each of you. And we've got Steve there, who's been involved in the drafting of the rules, and we have with Anna and Egbert different perspectives of business and the human rights community. So if I could just start with this question, why, perhaps I put this to Anna then, first of all, why would a business want to consent to arbitration in order to plug access to justice gaps for rights holders?
Thanks. I mean, I think your question goes to the heart of the issue from the business's perspective. And I suppose there's 2 elements to what you're saying, your question. Why would businesses consent to arbitration under the Hague Rules? Why would they consent to arbitration to plug access to justice gaps? And I think really the nub of it is in the second part of that question, because essentially, I think it is a mechanism whereby a company who purports to respect rights will see that it is in its interests, if it holds itself out to be aligned with, say, the UNGP, to be thinking about whether arbitrating under the Hague Rules would provide a plug for a gap in accessing remedy. So if we look at the UNGP, for example, a business has to provide or cooperate in remedy where it has caused or contributed to negative human rights harm. And it has to, in those situations, participate in legitimate processes. And another component of the UNGP is that businesses are required to carry out due diligence. Within that due diligence process, it should become evident to companies, if they're asking the right questions, that there are situations, jurisdictions in which they're operating, industries in which they're operating, where human rights harms are likely to happen. And in that context, the victims or rights holders of abuses that might ensue may not be available if court systems are not robust, essentially. And in those situations, you can see a company taking a decision to look at the remedy mechanisms that it makes available and considering whether actually arbitration should be one of those mechanisms. Already we know that companies are familiar with operational level grievance mechanisms and are, from the perspective of the UNGP, trying to make those more rights compliant. I do think that there is a place for considering arbitration as an additional grievance mechanism to add to that repertoire of grievance mechanisms in certain situations, which can see in advance that negative human rights impacts may ensue.
I think the reason I ask is that we've seen time and time again with cases that have been brought using judicial mechanisms, that where they are able to do so, companies will take technical points on jurisdiction, forum non-convenience, and so on. So I think that's probably what would make people skeptical as to whether they would voluntarily want to submit to a process which could lead to them being held accountable in circumstances where, if a judicial remedy is not available, they could avoid it altogether.
I agree with that. And I think there is a challenge for businesses, or for those trying to convince businesses that this mechanism should be an appropriate mechanism to insert, especially in their business-to-business contracts, that they would voluntarily open themselves up to the prospect of being sued. I posit the idea of extending the respect for rights into the context of thinking about grievance mechanisms as a mode for development. I don't think that businesses are necessarily there right now, but I think that it's worth considering against the risk of litigation, which is going to bring with it the very real risk of very public reputational damage that may, to some degree, be mitigated by using arbitration, for example.
Egbert, if I could just bring you in, what have you got any thoughts about this question of whether businesses are likely to engage with this? I think you're on mute, Egbert.
Yes, thanks, Richard, and thanks for having me today. Yes, I see very few businesses at the moment who seem to have strong incentives to resort to arbitration. Obviously, the system is tilted in their favor in most jurisdictions in the world. I mean, 5,000 people have no access to justice in the world, and even the remaining 2 billion, when confronted with large corporations, many of them will experience large asymmetry in power between them and corporations. So why would a business voluntarily give that advantage up? I do see, however, certain businesses interest to make other businesses do so, in particularly banks. Banks have embraced increasingly less voluntary human rights standards. They are increasingly faced with the risk of litigation, of being involved in financing projects that with adverse human rights impacts. And so you could imagine that banks might wish to put arbitration as an obligatory option in their financing agreements. The same with export credit agencies. They're very much government run, and governments, of course, I mean, to some extent, the UNGPs has given governments sometimes a bit a reason to take a back seat on business and human rights. You know, you society and business, you sort it out yourselves. But I think that we're now at the other side of the curve. We see increasingly a big tendency towards mandatory due diligence, and governments realizing that too much voluntarism doesn't really fill the systemic gaps. And with their sway over export credit agencies and insurance rules, etc., I could very well imagine that it would be an attractive option for governments to promote reference to arbitration within these business to business or export guarantee agreements, and that could potentially change the field dramatically. But we're not there yet, of course.
Steve, that's right, isn't it? That it may not be entirely in the hands of a business to decide whether they are subject to a Hague business and human rights arbitration if the requirement to arbitrate is incorporated into loan agreements and licenses to operate, for example.
Can I just add one small point, which is I think that's a very, very important mechanism. And indeed, if states do it, it's a way of their fulfilling their duties under Pillar 1. But I would just say that, you know, this is not a sort of theoretical possibility. We do have the Bangladesh agreement as an example of companies willing to sign up to it. And of course, we have the arbitration that you were involved in, Richard, involving Anglo-American, where again, a company was willing to go to arbitration. So, you know, this is something that companies have at least expressed the possibility for. Of course, in our consultations, we heard positive feedback from many companies. But it is, as Egbert said, going to take a while for there to be uptake, both by the people with the leverage and by the companies themselves.
Yeah, I mean, since you mentioned the arbitration against Anglo-American, it was against Anglo-American and Anglo-Gold Ashanti, and it was an arbitration of claims by gold miners who in South Africa who had sustained silicosis, a dust-related disease, and both we, on behalf of the victims and the company, could see distinct advantages in arbitration, particularly speed, and that successfully resulted in a settlement trust for the victims. So, yeah, there is some precedent for this to be used successfully and for there to be a mutual advantage. Now, I mean, how would the rules, Steve, perhaps I'll start with you. How do the rules enable victims to get a fair hearing, bearing in mind the power imbalance that obviously exists between them and business?
Well, Richard, this was, of course, one of the most important issues for the drafting team. We were, as I say, guided at all times by the criteria for legitimacy specified in Principle 31. And thus we drafted numerous provisions to address the economic and power imbalances. I won't go through all of them, but I'll just highlight 3 or 4 of the key examples. So, for instance, we have the article on representation empowers the tribunal to address barriers like lack of representation, language, costs, and fears of reprisal. So the tribunal can be more proactive and potentially use inquisitorial methods if the representation is not adequate for purposes of getting out the claim from the witnesses. Again, the article that I cited earlier about the qualifications of the chair of the panel are meant to provide for a fair hearing with the special required expertise and the code of conduct. There's an overarching article about the conduct of the proceedings that requires the tribunal to deal with imbalances. And we, in many places in the rules, refer to hearings that are fair, efficient, culturally appropriate, and rights compatible. And so that is meant to be the lodestar for the tribunal as they make all the decisions about procedures. Their article about how a party states its claim gives it a great deal of flexibility so that one would not expect that a party to be able to state a claim with the same level of detail as a typical commercial party would be expected to state it in order for the claim to be admissible. The article on evidence empowers the tribunal to deal with all sorts of imbalances. So, you know, maybe the respondent, its normal practice would be to do a sort of data dump on the tribunal and on the other side say, here's everything you asked for, now figure it out. And instead, maybe the tribunal would ask the party to provide it in a more digestible form given the potentially limited time available by the representatives of the claimants. So that's just a handful of the ways. I think we'll have a chance to talk about more when we get to issues about witness protection and others. But if you take a close look at the rules, if you look at the Q&A, you can learn a little bit more about this. But it is meant to provide a fair hearing to victims. There are, as we'll talk about a little bit later, also ways in which we acknowledge the concerns about of the respondents as well.
Now, Anna, this power imbalance and the ability of victims to get a fair hearing is obviously going to be a significant concern on the victim side. Steve has just outlined some ways in which that is going to be addressed. But do you think that, in view of this power imbalance, that businesses are going to be prepared in return for victims agreeing to arbitrate, for instance, to drop jurisdictional challenges?
I think that the mechanisms that Steve has just outlined are to do with the procedural fairness of the process. And in general terms, I think that most corporates, having got to the stage where they've agreed to arbitrate with rights holders, are going to be receptive and open to those mechanisms being in place. I would say, before I answer your question, that I do think that in the context of arbitration, actually, the tribunals are generally quite aware of due process considerations and the need to provide the parties with fair hearings, probably even more so than in a litigation context sometimes, because they're very aware of the enforceability of their award at the end of the day. I have, I suppose, one concern about some of the mechanisms that have just been outlined, which is that in empowering the tribunal to give more time for certain issues, there could be potential for delay in the process that could be unhelpful actually for both sides of the process. I note that there's a provision for an overarching provision for taking into account the urgency of human rights situations. I would hope that that would act as a counterbalance to that. But I just note that in general, in commercial arbitration, there is a sense sometimes that there's a sort of due process paranoia on behalf of the arbitral body or arbitral tribunal in any event, and would hope that these sorts of provisions would be used in a helpful way and not in a way that would just extend the process and make it more troublesome for all the parties involved. In terms of whether these mechanisms are a sufficient quid pro quo for giving up jurisdictional arguments, I think one of the helpful provisions that's not been mentioned yet, and we might come to talk to in more detail, is the provision about striking out claims which have no merit, manifestly without merit. I think that is a good counterbalance to some of these procedural measures that are intended to be more helpful for rights holders. So in that we see at least some mechanism by which claims which do not have any merit and are not likely to have any merit, even if evidence is provided to support the claim, noting that there are difficulties in that respect for claimants gaining access to internal corporate documents, for example. I think that counterbalances quite well some of these other mechanisms that we have in the rules.
So just to clarify that then, Anna, what you're saying is that the fact that a business is agreeing to arbitrate in a particular place necessarily entails relinquishing challenges that would otherwise be made on a jurisdictional basis, and that in order to compensate, in a sense, for that sacrifice, then we have these other provisions which enable strikeout in certain circumstances. We'll come on to that in a moment. But now, Egbert, what do you think about this? Because I mean, some of these cases are very complicated, aren't they? I mean, is it going to be possible, notwithstanding the assistance of an arbitrator, a helpful arbitrator, for victims to embark on some of these cases without legal representation?
They will always need legal representation, and there are obviously very, very large obstacles for people whose human rights have been harmed to decide to resort to arbitration. The drafting team has been very conscious of these obstacles and has talked about it and tried to take it away as possible, but it simply doesn't have the means or the instruments to actually really level that playing field, I'm afraid. I mean, Article 5.2 says that the tribunal will ensure parties effective opportunity to present a case, and it will ensure so taking into account issues like representation, financial cost and risks, fear of reprisals. But nowhere in the rules is there a mechanism to make sure that happens. Basically, this will cost a lot of time and money. Where would that come from? That is a large open question. Before a community or a trade union or whatever would decide on arbitration, they'll read the rules and they'll see that in case their complaint is unsuccessful, they're supposed to bear the cost of the other side. That is a huge disincentive. Now the tribunal has the discretion to decide on how this is done and whether this is done. But unless it has its own source of funding, I wouldn't know how they could use that discretion unless the corporate side agrees basically to pick up the bill in the end, or you need some foundation who compensate for that.
You're raising there are a number of points there, and I think the question of costs I was going to come to in a while, but since you've raised it, I suppose the point that would be made in response to that is that even with existing judicial mechanisms, there are usually these potential cost sanctions which can act as a deterrent. So in that sense, if that potential exists in an arbitration, it's no different from the position with a judicial remedy. But as you say, the rules do give the power to an arbitrator to vary that allocation of costs. So they could, as we have in the UK, for instance, in certain circumstances, stipulate that there will be one-way cost shifting. In other words, that it's only if the business loses that costs will be payable, not the other way around.
Well, that would be fantastic.
Yeah.
Just add on the issue of cost that there are, of course, ways in which the tribunal can reduce the costs of the proceedings. It can. It needn't require the witnesses to come to wherever the hearing is held. They can go to the witnesses, or they can be done remotely. There are actually the PCA and other arbitral institutions have developed a number of ways to keep costs down. But in the end, the lawyers for the victim survivors aren't going to have to get paid one way or the other unless they're doing it pro bono, and that then they need some kind of external source of funding from some foundation or somebody else. And although and if they are unsuccessful, the arbitration rules provide that they wouldn't have to bear. There's a possibility that they wouldn't have to bear the cost of the other side, but they probably would still have to bear their own costs.
Sure.
And if they're unsuccessful, and so that does raise larger questions that go, I think, well beyond arbitration to the general problem of advocacy in human rights cases.
Of course, if victims were deterred from agreeing to arbitrate because of the costs of the arbitration, being asked to contribute to the costs of the arbitration or to accept the risk of an adverse costs order if the case is unsuccessful, they may simply decide that they don't want to arbitrate at all, and then it will be a choice for for the company as to whether it wants to agree to waive those risks at the outset. So that's a possible answer, isn't it? And in fact, in the Anglo-American arbitration that I mentioned, it was agreed at the outset that the company would pay for the arbitration, and that it would all be public. And if that hadn't been agreed, the claimants would not have agreed to arbitrate. So it can work that way. But what do you say about legal representation, Steve? I mean, is it realistic for victims to engage in this kind of process without it? It's not, is it?
I mean, it's very hard to imagine an unrepresented claimant. At a minimum, one needs a counsel who have experience with some kind of litigation, whether it's domestic litigation or international. I do think this is one of the challenges, is, you know, thinking about how might one come up with a roster, not only of potential arbitrators, but of potential litigators, and how we'd have to be thinking about fees in a very different way from what we think about fees in international commercial arbitration or investor-state arbitration.
Now, I don't know who it was who mentioned the provisions in the rules for protection of witnesses, anonymity, and so on. I mean, that's clearly very important in certain circumstances, that victims' identity should not be known. Egbert, I mean, that is really crucial, isn't it?
It can be in many jurisdictions. I mean, we're living, many countries have very repressive regimes. I think an arbitration system like this is not likely to work in many. And I was going to work in China, or you know, does anyone see a community in Siberia taking Gazprom to arbitration? I don't think so. And but in other jurisdictions, yes, they could. Even though I must say, take Latin America, there are a country like Colombia. You could imagine a community, they're well organized, they tend to sometimes be being truly representative of communities, still making trouble, so to speak, from as seen by corporations or by political powers that be, could by itself be dangerous, and expose individuals and groups to serious danger. And I don't think that the rules or any arbitration system can completely balance that. You know, you can't provide security as a forum in such a jurisdiction, but in specifically witnesses. Naming individuals, yeah, I could imagine that if you do that right, it could make it attractive for certain harm groups to take things to court or to arbitration that they would not otherwise. But I must say that here in general, I see the NGO community as a whole a bit failing. There are a lot of NGOs, a lot of lawyers also, who are really keen to take corporations to court for serious human rights violations. But there is no system to protect the witnesses, and very, very, very often it is very dangerous to testify against a corporation, not necessarily because the corporation itself will take action, but those in those countries who consider their interests to be aligned with the corporations, they will. They very often do. And as far as we have protective programs, you know, NGOs have protective, it is very much human rights defenders programs that is based on taking people out of a situation for a few months. Maybe offering asylum, that happens, governments do that. Also in cases of you know, several cases of litigations against corporations where witnesses have been granted asylum in safe countries. But there is no systemic approach, because a witness protection program is quite different from a human rights defenders assistance program that we are having. And so here again, yes, the anonymity may to some extent protect witnesses, but very often it will not be enough. And if people have reason to fear, they have reason to fear. And only anonymity will not necessarily make them trust a system that they don't really know.
Steve, I mean, that's great, isn't it? I mean, that there are obviously certain situations that where this system is not going to be feasible for the reasons that Egbert mentions, but nevertheless, in many other situations, there are important safeguards in these rules for witnesses and claimants.
And counsel as well.
And counsel.
All three there. Yeah. I guess I would just add, of course, what Egbert is saying is right about the challenges to actually going from the rules, which contemplate situations where the tribunal is going to need to order anonymity or even protection of claimants, witnesses, and counsel, to actually operationalizing that. Now, there are best practices that you can look at from, let's say, the international criminal tribunals for keeping people's names out of the public. Less experience in other situations, but the tribunals would definitely need to be looking at those experiences to make it meaningful and to actually provide for the protection that's needed.
Okay. Now, something quite close to my heart, I must say, because of the types of cases that we do, is some of the provisions on access to documents, which is obviously crucial in some of these business and human rights cases, particularly access to internal corporate documents. So these rules have provisions in them which enable or ensure disclosure of relevant documents. But there's an interesting provision here, or possibility here rather than being expressly stated, Anna, which is the possibility that if a party fails to produce documents, then it could be that the arbitrator decides to reverse the burden of proof. So if a company, for instance, which is alleged to have been engaged in wrongdoing and caused human rights abuses, fails to produce relevant documents, then it could end up having the burden of proof shifted to it. I mean, how do you think businesses will be willing to go along with that?
I think that is the way you've just expressed it as actually shifting the burden of proof is certainly new. I think the core principle that underlies that, which is in the court process, that you have to provide, the corporate would have to provide documents both for and against its case, would in some ways deal with that situation, in the sense that it would need to provide those documents. They would be flushed out, and if they weren't, adverse inferences would be drawn as to why they weren't, and orders would be made against the corporate. In the arbitral context, evidence, the provision of evidence is somewhat different, and starts from the premise that you provide the documents which you wish to rely on, and then you have a process by which you respond to requests. And it is true that in arbitration, there are fewer sanctions really around the non-provision of documents, because it's not backed up by the type of measures that the court can take. So I think the insertion of the shifting of burden of proof is an interesting mechanism by which to try and close that gap that is inherent in the arbitral procedure for reasons that are actually to do with the history of arbitration being a combination of civil and common law procedures, whereby the kind of disclosure that we see in English law is not the usual method. I think that corporates will find that a difficult provision. That said, as I mentioned earlier, to the extent that it's akin in essence to that the end result will be similar to what you might experience in the courts, then it may be just about palatable. But I think really the question is what conclusions can be drawn if a corporate is wanting to amend the rules in that respect and take that provision out. Is that something that it wants to be seen to be doing at the outset of an arbitration or even in the rules to start with? And I think that's where some of the considerations about why the corporate is entering into the arbitration in the first place need to be examined.
I would have thought if a corporation did want to take that out, that might deter the claimant from engaging in the process, bearing in mind the power imbalance that there is. So, well, I mean, those are the. I mean, we're picking out some of the issues that are going to be quite tricky for both sides, aren't we? Now, multi-party actions are provided for under these rules, Steve. Quite important where you've got a large number of people who've been affected, let's say by an environmental pollution incident. You may have a whole community of people whose rights have been violated and who want to take action against the company. And in order for that to be practically possible, they have to join their cases together in the form of some kind of group or class action, and that's provided for under these rules, right?
Yes, there's a specific article dealing specifically with this question. It's Article 19. There's the possibility of joinder of separate cases with similar or substantially similar issues of fact and law. But then there is this possibility of adding parties, third-party beneficiaries to the underlying contract, or third parties or third-party or other beneficiaries of the underlying contract, or third-party beneficiaries or parties to the underlying arbitration agreement. The procedures are slightly different in those two situations, but certainly this is actually to be expected, because if the issue is going to come up, we can expect that there would be in numerous forms of business contracts, third-party beneficiaries, and it would be advantageous to resolve the dispute by bringing them in into it as third parties.
Anna, you mentioned earlier on the provision for striking out of claims that were manifestly unfounded. I think that's the manifestly without merit is the expression used in the rules, and that being important to business in order to not to incur a lot of expense in dealing with such claims. On the other side, of course, the concern of victims is that that type of application and also the provision for counterclaims to be made by business could be used in an oppressive way against to intimidate victims. What do you say about that?
I think that the provision, as I say, is fairly pro-business and acts as a good counterbalance to some of the evidential provisions that we saw earlier. I think you're right that it's possible that it could be used to slightly undermine the evidence provisions, in the sense that it would bring a determination of the merits of the claim forward, albeit on a preliminary and dispositive basis, because it could be used by corporates really as soon as the claim is initiated to bring up front an assessment on the merit of whether the claim has any legs, essentially. and there aren't safeguards to deal with that in the rules. I suppose one would have to rely on the expertise of the arbitral tribunal to take that fair view and to set a threshold for the assessment of whether or not the claim is manifestly without merit. And of course, there's nothing in the rules that tells us what that test is. We don't have court precedent to fall back on. We would have to rely on the arbitral tribunal taking a fair view of the application.
Steve, though, I suppose if a company made an oppressive counterclaim, then these rules also enable the arbitrator to strike out that counterclaim as being manifestly without merit at an early stage. So that is a safeguard.
They can strike out the counterclaim. They can, and the way the rules are worded, they can actually deal with a manifestly ill-founded defense. So if the tribunal were to respond to the original claim with some kind of ad hominem or just outrageous attack on the claimants that avoids the issue and potentially puts them in some kind of harm, the tribunal can deal with that quickly. It's exempt from the transparency rules, and so it's meant to be symmetrical in that way.
May I say something again about that?
Sorry, yes.
Yeah, sorry. About discovery. It's not directly related with the rules, but it's one of the reasons why they could be really important. The many corporations in the world have a code of conduct where they say that they support or even promote respect for human rights, and but if you see in their legal strategies, they never do that. The problem with the law and lawyers is, of course, that it's a principled and adversarial situation that's been created, and but if a company has an issue with the victims of human rights violations, you would expect, and you should expect, if they want to respect and promote human rights, that in their choice for a legal strategy, they would take into account the right to access to justice and prompt redress of these people. They never do. It doesn't happen. The thought doesn't. It seems to occur very different. Doesn't occur. Now, this would, if they would, it would, I would say, have consequences for two typical parts of a legal strategy, and one is discovery. This is access to information. If you want to balance in your legal strategy your own interest and that of, even if it's adversarial, of the rights holders, the truth must be put on the table. Otherwise, there is an imbalance. Otherwise, you basically deny the other access, his right to access to justice and prompt redress. And that's a reason to be enthusiastic about the rules, that it says, well, there can be discovery, and basically the tribunal can impose a much larger, basically can stop that strategy when it comes to information sharing. The other one would, of course, be delay tactics, and then you have slapping. And here also, I would say a tribunal, it can do things really speedy. I don't see many ways in the rules, many invitations, so to speak, to corporate lawyers to delay the process a lot. So that's also a positive element.
Now, I'm afraid we're running out of time here. I want to allow some time for questions. It's my fault for perhaps allowing things to drift a bit. Can we just deal with two aspects then before we move on to some of the questions that have come through? Two aspects. One is about rights compatibility and cultural appropriateness of award, which does feature quite heavily in the discussion on the rules, and the second is to do with transparency. So, Steve, perhaps I could just ask you to explain this concept and how it applies to these rules: rights compatibility and cultural appropriateness of award. Why is this? What is it, and why is it important?
Sure. These are concepts both from the UNGPs, but also especially with respect to cultural appropriateness, that became very clear in our consultations with stakeholders, and also from the expertise of individual members of the drafting team. So it's very important that the tribunal be very sensitive to the situation in which it's dealing. There are many situations where certain evidence is going to have to be approached in a different way, depending on sensitivities about what is appropriate to be revealed to third parties like a tribunal, the examination of witnesses, many different phases of the process where the tribunal is just going to have to remember who the victims are, and that this is not an international commercial arbitration. And so this was added in a way that simply doesn't appear in things like the UNCITRAL rules or the ICSID rules, added throughout. On the issue of rights compatibility is something that has to be front and center during both the proceedings themselves as well as the award, and they're dealt with in different articles. During the proceedings, again, it's very important to be aware of the human rights of the individuals, and that nothing be done during the proceedings that would place them at harm or somehow make things worse for them. But secondly, and critically, is the requirement that the award itself be human rights compatible. And this is essentially a check on the award that the tribunal has to do to ensure that there's nothing in it that would, in a sense, violate human rights directly, or force require the losing party to violate someone's human rights. Now, we don't define the term human rights compatibility because it really is something that has to be worked out through the jurisprudence of the tribunal. But it is important. It also could come into play at the enforcement stage, as in terms of the exceptions to enforcement under the New York Convention. So there has to be that sort of check may play a role in ensuring that there's enforcement. I would just say the last one I would simply make is that even if there is a settlement, if the parties reach a settlement that they then want the tribunal to convert into an award, which is sometimes done rather than simply closing the case and then having a settlement setting that's separate, the parties can actually ask for the settlement to be converted into an enforceable award. In that sort of situation, the tribunal has to be unanimously satisfied that the award is human rights compatible, so that it doesn't put its imprimatur on a settlement that the parties may have worked out, but that still is not human rights compatible. So those are the intentions of the drafting team.
Okay, that's very useful. Now, the second issue then is this question of transparency, which is certainly the preference, the default position under the rules. But Anna, I mean, that there's obviously a bit of a tension here between the inevitable desire of business for things to be confidential and not too much in the public eye, and for that to be a motivation towards arbitration, whereas on the part of certainly victims' representatives, public interest organisations, for there to be full transparency. I mean, are businesses likely, how likely is it, do you think, that businesses will agree to transparency and of pleadings and hearings and awards, especially where victims are in a weak bargaining position, where there is little access or effective access to a judicial remedy available?
I have to say, I think this is one of the most difficult parts of the rules from the corporate perspective. The idea of full transparency of the hearing, of the award, of everything without any redaction is extreme and in some ways unprecedented, other than in respect of ICSID arbitrations, i.e. investor-state arbitrations that are specially designed for the type of public interest issues that I was describing earlier. To take, as you said, a corporate from the perspective of being minded to offer to arbitrate, i.e. with a conclusion that might lead to a finding of liability against it, and also say to that corporate that they have to agree to full transparency, I think is going to be problematic. I think more likely you'll have a situation where limited transparency can be agreed in certain situations. I note that in the Bangladesh Accord arbitrations, there was transparency to a degree. Notably, the respondents' names were redacted. And so clearly that was something that the respondent company felt very important to keep under wraps. But other features of the procedure, albeit that there wasn't actually a substantive award at the end of the day because the matter settled, were made publicly available. And I think that something that goes towards transparency, but makes a concession to the idea that corporate is, as we've been discussing throughout, is voluntarily accepting to arbitrate with the rights holders is the most likely situation. That said, I think what is appropriate will depend on the dispute at hand, and there may be circumstances where after a dispute, especially, well, there may be situations where fuller transparency may be appropriate, perhaps where there are multiple parties who may be having responsibility for the issues at hand and states are involved as well as corporates. That might be a situation where transparency may be more appropriate.
Of course, I guess in circumstances where there is no judicial remedy available and monetary compensation is important to victims, impoverished victims, then a confidential arbitration is arguably better than no redress at all. Indeed.
And unfortunately, that's an assessment that the rights holder will have to take at the outset before deciding whether to bring their claim and going into bat with the corporate negotiating these provisions.
Okay, can I just, before we move on to questions, can I just finish by asking each of you to address one kind of overarching question, which is whether, taking everything into account from your perspectives, whether you feel that these business and human rights arbitration can contribute to the long-term protection of human rights. That is, beyond the particular dispute where it's utilised. Steve, perhaps I can start with you.
Well, I guess I would just make one a preliminary point to follow on what Anna just said, which is that there is, just as there is tension on the corporate side between the desire for a good reputation on the one hand, and then this sort of litigious side, which is focused on sort of short-term gains. And there can be disputes within corporations about which is more important that will affect the entire process. So on the side of the survivors and victims, there may be a tension between accountability in a public sense and actually the remedy in the sense of the immediate award for the victims. And they may push in opposite directions, and especially if you have a confidential proceeding or a confidential settlement. So I would say, in response to your question, that I do believe that individual awards have great potential for advancing human rights insofar as they do provide the remedy, and insofar as, to the extent they are transparent, which we hope and expect will be with respect to most of the proceedings, they offer a process that can be viewed so that business is aware of what their responsibilities are and what the consequences are for not complying with them. The rights compatibility of the award provides an additional check on that. The transparency of the proceedings, the publication of the awards, we hope the keeping of a repository of the awards by the PCA. This is obviously a very, very long-term process, and we're not talking about the amount of case law of the International Human Rights Courts. But over time, if the business stakeholders become aware of the the ways in which they are at risk if they don't comply with human rights, I do believe that this represents a promising complementary mechanism to the other mechanisms discussed in the Pillar 3. Thanks.
Thanks. Anna, what do you say?
I agree that the ability to have available, to the extent they are made transparent, awards that create a corpus of examples where business and human rights disputes have been battled through to the end would be very useful and would inform disputes in all sorts of forums. I think that the engagement of corporates and rights holders in the process itself, having got over the idea of voluntarily submitting to arbitration, is in itself likely to be a beneficial one. We've been discussing some of the challenges at this point of getting businesses' head around this idea, and to some extent, well, to a large extent, rights holders also have their reservations about the trust of the process. But I suppose, being optimistic, I think those challenges can be ironed out over time, and there may be a way in which this mechanism can be a trusted way of providing access to remedy to avoid some of the hurdles that we have with litigation.
Egbert, are you optimistic?
Always, by choice. There are some obvious advantages compared to existing mechanisms. I mean, I don't see the rules as a replacement of anything that exists, of course, and it doesn't do any harm. It is there. It's just another tool, and which with clear advantages. I mean, its outcome is binding compared with the national contact points of the OCD mechanisms that's at a very low threshold, but that is not binding whatsoever, and there are very few NCPs that actually function acceptably. So it's much better in that aspect than a widely accepted mechanism like the national contact points. Its speed and effectiveness have been mentioned. Independence of the court, discovery, and of course the interim measures. I think that could potentially become a very important tool. But it has to become integrated. I mean, we have to develop it. We haven't had a case yet. I'm not aware of any listed company who is publicly endorsed or supported the rules as yet. So it's really the jury is out. But I don't see any fundamental reason why it cannot develop into an additional tool, considering the big obstacles that I mentioned, that we have to find ways to remove.
Good, thanks very much. Now we've had several questions. I'm not going to be able to go through all of them, I'm afraid, but I'll do as many as we can. We've probably got another 15 minutes available. There's a question about a topic that we didn't cover, which is the interim measures concerning the interim measures provision in the rules. So there are questions about whether the process can be used if there are imminent dangers, yeah. So so that's the question: whether, if in an emergency situation, the rules can be used. Steve, perhaps you could answer that one.
I may have tapped in a quick response on the chat, but sure. There are two different ways. There is a clause on interim measures with the clear power of the tribunal, and again, distinct from, let's say, the UNCITRAL rules. One of the grounds would be to prevent serious harm to the enjoyment of human rights. And the tribunal also has the power to order non-compliance, sanctions for non-compliance, and require the parties to post security if necessary. The second provision, which is unique to the Hague Rules, is the provision providing for the possibility of an emergency arbitrator. So that if you had a very time-sensitive situation and you didn't even have time to get a whole tribunal together, a party could request the appointment by the PCA or other appointing authority of an emergency arbitrator who would have authority to in a very, very expedited procedure, to make various orders to try to to prevent an aggravation of the situation pending the establishment of a tribunal in the full proceedings. And this would not affect the rulings on the merits. So yes, these were both very important. I was made aware to us by civil society actors on the sounding board and others. And so we try to address these concerns.
Okay, here's a question that I think will appeal to Egbert. I'm not sure whether it will appeal so much to you, Anna, but someone has suggested that companies should be forced to, companies who want to use the Hague Rules should be forced to pay into a fund to support the claimant's costs. I give the example of sports arbitration, where sports governing bodies bear much of the costs for operation of the Court of Arbitration for Sport. So, Egbert, I'm sure I would have thought that would find favour with you, that idea.
Absolutely. I'm not sure whether it will find favour with the CFOs of these companies, because they're paying money and they don't know what they're getting in return. But of course, yeah, I'm very much in favour of I think in the end the tribunal will need some kind of independent source of funding for itself to be able to really deliver its promise, and this could be a way to fund it.
Anna, that's right. I mean, if we restrict the discussion to the costs of the arbitration rather than the costs of the claimant's or the victim's legal representation, and that's going to be pretty inevitable, isn't it? That businesses are going to have to pay for the arbitration.
Well, the usual rule, of course, is that claimants have to pay for the arbitration. And we see often examples where a claimant is paying on behalf of the respondent for their share of the arbitration costs, because the respondent essentially says that it has the right to participate in the procedure, but at the claimant's cost. So what you're suggesting with a fund up front is a reversal of that. On the presumption, of course, that the corporate is liable. I mean,
sorry, I don't mean the claimant's legal costs.
You mean the arbitration costs of the?
I mean the costs of the arbitrator's costs.
Yeah.
The cost of that.
No, I understand that, but I think the same rule generally applies. So I think that, I mean, I was interested to hear the example you had with the Anglo-American example earlier. There clearly are situations where corporates are amenable to these sort of negotiations. I think that if there was a fund that was made available for the tribunal's costs, and any institution that is involved in the arbitration, if that's what the parties agreed, I think it would have to be subject to the principle that is in the rules at the end of the day in terms of allocation of those costs once liability has been determined.
I mean, to be honest, I would think the arbitrator's costs are going to be almost a drop in the ocean compared to the costs of the company's lawyers.
That's right. And I think, am I right in saying that there's a cap that's been suggested, that the arbitrators provide an estimate of their costs in this process? So that's a way, as you mentioned earlier, Steve, of managing those costs up front, so that at least that they are a known entity. And I think that would play in a claimant's favour in arguing for this kind of advanced cost being paid by the respondent corporate entity.
Steve, there's a question about the sound. Sorry, did you?
Just going to the point that Egbert made. You know, there are many ways in which different stakeholders can build on the Hague Rules, and the idea of a trust fund or a victims fund. Obviously, there's all sorts of possibilities under different institutional umbrellas, and just as we now have, for instance, you know, in the WTO, essentially a small institution that assists developing countries bringing cases in the WTO to provide for somewhat more even playing field in that state-to-state context. It's not unimaginable that there could be a number of governments that are willing to donate to a trust fund to make business and human rights arbitration more appealing to the victim claimants.
Steve, there's a question about the sounding board group here for you. Interested to understand how the sounding board group was able to understand the rights holders' victims' perspective, where they're not directly part of the sounding board group. Were past victims of human rights breaches consulted?
the short answer is, in a sense, the views of victims made it into the process, or were very much considered by the drafting group in two senses. First of all, experiences of individual members of the drafting team, including Richard, and including another member of the drafting team who runs a human rights NGO in rural Argentina, where he works on mediation of business and human rights disputes at a community grassroots community level. On the sounding board itself, we had a very diverse group of NGOs that were participating in the sounding board. And one hopes that the NGO is in touch with their stakeholders. I believe, knowing what I know about the NGOs that were involved in our process, they were extraordinarily reputable and with real grassroots experience. So I was confident, and I think others were, that they were passing on their own experiences about the hurdles to victims. And there were just numerous conversations all along the way where we thought about whether how different victims might react to this or that rule, or how their counsel might react. So it was certainly our effort to incorporate those views through the sounding board and through the team itself.
There's a question here from someone who obviously knows a lot about arbitration, so I don't want to display my ignorance. I'm going to give this one to you, Anna. I don't know what this is a reference to. Do you think Section 69 of the Arbitration Act, which covers appeals on points of law, is too weighted in favour of commercial parties? If so, what reforms would you recommend to that section?
I suppose what that might be driving at is the fact that Section 69 is a provision that can be carved out. So of the three grounds on which an award can be challenged, the ground in 69 of the Arbitration Act, which provides for an appeal on a point of law, is one which the parties can agree can be dispensed with. And so I suppose the argument would run that by corporates having the upper hand in framing the terms of reference for an arbitration in a BHR context, they would seek to carve that out and not allow that sort of stopgap from the English courts on points of law, and that might be detrimental to rights holders. So I mean, I think that there's probably for a longer discussion as to the evolution of Section 69, which is actually an oddity. So a lot of other arbitral rules do not have, arbitral laws do not have that provision in it. And I think it would take quite a lot to pitch for that to be amended to make it mandatory. But it's definitely an idea. The other safeguards that are in the Arbitration Act to do with the procedural regularity of the award and whether the tribunal have had jurisdiction, proper jurisdiction to determine the award. And those are common across all arbitral awards. Sorry, arbitral laws.
Mm-hmm. There's a question here about transparency, which we did discuss, but I don't know if you commented on that topic. But the question is, I mean, it kind of retraces part of the discussion that we had. An advantage of arbitration is that disputes can be resolved in private. Is this consistent with the importance that the UNGPs place on transparency?
Well, transparency has a deterrent impact. I mean, that was one of the reasons, I believe, why it is giving so much priority. It's not necessarily always very important to a specific group of people who are harmed. And on the other hand, I tend to believe that confidentiality is grossly overrated among corporations. They want to keep almost everything confidential, and very often I really don't understand why. And if you ask them, they don't understand themselves. It's more of an instinctive reaction than that it really makes sense. So to have a default position of transparency, unless I would say that that's important. But there are also proponents of transparency, you know, as if transparency is going to resolve some of the fundamental ills of the world, and it's not. Also, transparency must serve a purpose. And so I would say transparency, for that reason, should always be negotiable. It's never a, it's not something sacred. It must serve a purpose. And but clearly the rules provide, and the default position is transparency, and there's all kinds of ways to negotiate it, and I would consider that a healthy thing.
Mm. And of course, in certain circumstances, victims will want the whole process to be confidential.
Of course, openness can be risky, huh? Also for victims, of course.
Exactly.
I would just add, I mean, it's important to distinguish between the access to the documents for the victims, for the parties, and the public dissemination of the document. Those are two different issues. And with respect to the first, you know, the rules of the Hague Rules, basically, you can't just say we don't want to turn this over or we think it's embarrassing. They're very, very, you know, if the document is relevant, there have to be very, very specific reasons that the tribunal accepts for why it wouldn't be handed over to the other party. On transparency, there are a larger group of exceptions that include the possibility that some internal corporate documents would not go into the public realm. But that would not prevent them from being seen by the other party during the arbitration.
Mm. Yes. Now, there's a question here about how do the Hague Rules fit with non-judicial corporate level grievance mechanisms and stakeholder consultation procedures? Steve.
Well, I mean, in a sense, they can be built into grievance mechanisms, which is to say that if the victim is not satisfied with the grievance mechanism that the company sets up, then the company could agree to the arbitration. As far as the relationship to other forms of dispute settlement, there is a provision about mediation, but mediation very, very broadly defined. And indeed, again, from various expertise on the drafting team and from our consultations, the range of mediation techniques is enormous, involving grassroots consultation. And at any point, the parties can put the arbitration on hold if they want to have recourse to those. And certainly we recognize that those are valuable and maybe both cheaper and faster than going through the arbitration.
Nevertheless, I mean, there is considerable concern about some of the corporate grievance mechanisms that have been established in the past. Okay. Right, well, look, everyone, I think we need to leave it there. It's been quite a long session, and a lot to get through, a lot of different issues that we've discussed. And I'd like to thank all three of you for the very clear explanations that you've given, and the discussion. I hope everyone who's attended has found it worthwhile and interesting. I certainly have, and I hope it's has generated some interest in the potential use of these rules, which I share the optimism that the three of you expressed about. So let's see where things go. And thank you to everyone who's attended. As I say, I hope you found it worthwhile. So thanks very much.